Bonjour tout le monde. Hello everyone. Je suis extrêmement heureux de vous accueillir aujourd'hui pour une nouvelle conférence virtuelle du CDTS. I am delighted to welcome you for a new virtual talk presented by the University of Ottawa Research Chair in Technology and Society in collaboration with the Citizen Lab at U of T and the AN Society Initiative. For those who don't know me, my name is Florian Martin Barito. I am an associate professor of law, the University Research Chair in Technology and Society, and the director of the University of Ottawa Center for Law, Technology and Society. For today's virtual talk, I am delighted to host a conversation around To Surveil and Predict, a human rights analysis of algorithmic policing, the latest research report from the Citizen Lab and the International Human Rights Program at University of Toronto. And when we discuss algorithmic policing and facial recognition, etc., one of the biggest questions is like, in the Canadian context, is algorithmic policing fundamentally incompatible with the Charter? And to answer that important question, I'm delighted today to be joined by the authors of the Citizen Lab and IHRP reports. So Kate Robertson, who is a criminal defense lawyer at Markson Law in Toronto and a Citizen Lab research fellow. Cynthia Ko, research fellow at the Citizen Lab, a technology and human rights lawyer and an alumni of the center. And Yolanda Song, a civil litigation lawyer at Stevenson Walton LLP in Toronto and a pro bono research associate at the International Human Rights Program at the University of Toronto. And without further ado, I will hand it over to our guest that will present their report, and then we will have a Q&A session with the rest of the audience. Again, I will invite you to ask your question even during the talk in the chat in Teams. So again, just click on the chat bubble. Kate, Cynthia, Yolanda, the floor is yours.
Thank you very much. And we're very happy to be here, all three of us, at this important series and bringing this topic to the audience today. We've, in our report, set out to build on important scholarship in the area of algorithms and issues relating to human rights and equality, and how some of those issues come to the forefront when you introduce algorithms into policing, as we've seen in other countries around the world. This report is a fact-finding and human rights analysis with respect to algorithmic policing in Canada. Just working on a technical, here we are. One moment as I get my slides in order. Perhaps I could ask one of my co-panelists to get us back to our first slide. It seems to be glitching a little bit while I introduce us. So algorithmic policing generally has two different classifications that we've used to understand what algorithmic policing technology is. On the one hand, there's a class of technology called predictive policing, which is the use of mass historic policing data sets to attempt to draw inferences about potential future crime that may not happen. Sometimes it focuses on locations of potential crime. Sometimes it's focused on persons who may be at risk of being associated with crime in the future. There's examples of these programs already in use in Canada, in both Vancouver and Saskatoon, respectively, one of each kind. There's also a class of technology referred to in our report as algorithmic surveillance technology. And this is a different type of technology because it uses automation or algorithms to extrapolate and expand traditional police surveillance techniques on a massive scale. And so we've seen a number of examples of this in what we've known about algorithmic policing in Canada. It includes facial recognition systems, social media, surveillance, license plate readers, which are a type of technology that de-anonymize and track the movements of cars moving about cities, and social network analysis, which is the use of algorithms to draw linkages between communities. And this is in a way a hybrid between the two, predictive policing and algorithmic surveillance tools. And it's important to understand, generally speaking, particularly when we're talking about predictive policing, that we're really not in any way close to a minority report scenario. When we're talking about predictions drawn from algorithms, we're talking about generalized statistical forecasts that are extrapolated across very large swaths of society, and it becomes highly questionable as to whether or not certain inferences can be drawn to particular subgroups within society, even assuming that they're statistically accurate at a very broad level. So that's something to always keep in mind when we're talking about the human rights analysis, is we're talking about a very sometimes rudimentary type of technology compared to what you might expect from a science fiction portrayal of these technologies. We could go to the next slide. Generally speaking, what a metric in order to understand some of the impact of algorithmic policing is what's referred to as the 3 V's. It distinguishes traditional policing methods by data collection and aggregation, and sharing and integration in a very distinct way that has unique privacy and human rights impacts. We're talking about high speeds, volume, large data sets in terms of volume, high speeds in terms of volume, velocity, and a variety of data is all pulled together to draw distinct and unique inferences about potential future activity. If we go to the next slide. We've found in our report that the human rights effects of algorithmic policing and surveillance include interrelated impacts in a number of areas of human rights protection, including privacy, equality, freedoms of expression, and freedom of association. I'm going to, for myself, focus in particular on privacy and fundamental freedoms like expression in the first portion of this presentation. When we're talking about the deployment in particular of automated surveillance, it has a tendency to transform public spaces such as online forums and spaces within cities in a very impactful way from a human rights perspective. And so when you think about what might take place in a public protest in a city, the layering of algorithms into the interaction between the individuals and the state becomes that much more risky and contested. If we go to the next slide, the important umbrella perspective to keep in mind when we're looking at the legality of automated surveillance techniques is to recognize that our law has long moved away from a conception of privacy as secrecy. What our privacy law protects is enabling a zone of privacy or zone of freedom to enable expression, autonomy, and liberty. And prior to the deployment of intrusive surveillance technologies, we were able to exist in cities and online environments with a freedom that comes with a relative anonymity from our other fellow community members. And so what I mean by that is that when we walk down the street, if we stand outside of City Hall, post to our social media accounts, we don't expect to be part of a systematically gathered case file or to be identifiable even, except for the handful of people that know us or who are in our social media networks. And this type of freedom is particularly important for equality-seeking groups who depend on access to public forums to engage in expressive and associational activity to regain lost liberty and equality caused by systemic discrimination. And so we see really impactful layers of ways in which algorithmic surveillance technologies intrude into these zones of freedom. That includes data collection methods, the way that we see data processing occurring by police services in new ways, such as the repurposing of data that was traditionally obtained in a regulatory environment that didn't contemplate complex, sophisticated algorithms, and then very complex and thorny issues relating to sharing, particularly when we're talking about sharing from outside of law enforcement entities to within law enforcement entities, which is a very, very complicated area that our courts haven't been required to squarely engage with significantly yet. And so when you think of the introduction of algorithmic policing into outdoor and online environments, it's important to recognize that it's like changing the rules midway through the game. And so if you think of the rules that may not have existed at the time that law enforcement became able to freely install video cameras throughout cities and access footage on them. With the deployment of facial recognition systems, it significantly changes the privacy impacts and therefore the legality impacts of that type of data access and collection. And this is particularly so given documented biases with facial recognition systems for Black individuals and women, for example. And it really heightens the impact of historic biases that we know is in our arrest data, for example, and that racialized faces are overrepresented in our police mugshot databases where these facial recognition systems are deployed. And so really, law enforcement authorities perceive a free license to deploy tracking, monitoring, de-anonymizing technology because they currently do so in these algorithmic spheres in areas that are public, and I put that in air quotes. It's sort of open source technique. The idea of something being open source is a highly contested concept, and it's not it doesn't have predictive value as to whether or not it's a legal technique anymore. Human rights law is not so simplistic. It protects normative values. And so if we could go to the next slide, we're just highlighting the linkages between these privacy impacts and expression and association. We know that non-algorithmic social media surveillance has been used to monitor online activity around events such as protests by racial justice, social movements. This has raised concerns for how human rights are impacted by more powerful algorithm-driven versions of that type of activity. If you go to the next slide. We know, for example, that a software company called Media Sonar was banned from Twitter and Instagram in 2016 because it violated the privacy policies of those platforms. And this followed a revelation by the ACLU that the company had been encouraging law enforcement agencies to identify threats to the public safety by tracking racial justice keywords like Black Lives Matter. And police services in Calgary and Toronto used this program before it was banned. Toronto currently has another social media analytics software that they haven't disclosed the use of in terms of how it's being deployed. The RCMP is also well known to have been involved in social media analytics and surveillance for some time through Project Wide Awake. We also know as of last month that they've entered into a contract with a company called Babel Street, which is a particular concern given the company's notoriously invasive capabilities, can filter social media content by geographic area, by hashtag, and it mines information from over 25 social media sites. And so to the extent that these technologies are being used, particularly in respect of expressive activity such as protest, we know that the litmus test is the police activity causing a chilling effect. And this is an area that's very ripe for improvement within the litigation, within our case law. The courts have imposed inordinately high and unrealistic evidentiary burdens when we're talking about proof of a chilling effect on protest. And when you look at the idea of grassroots activism and the potential effect of these technologies, it can be very difficult to expect that the same individuals who are attempting to express themselves through this type of activism can somehow simultaneously gather evidence of a chilling effect is very difficult, and an equality-based analysis of the evidentiary burden is essential. And I would highlight for academic researchers that may be listening today, if this is an area of interest for us practitioners in the justice system, having common sense inferences documented in the form of academic research is very helpful. For example, John Penny is a colleague who published a study in 2017 talking about the chilling effects of internet surveillance on free speech, and that was cited by a judge of the Supreme Court very appropriately. And so So as it stands, we've said in our report that our legal system is currently ill-equipped to be able to provide adequate enforcement to the types of interests that are at stake, and we've called for mandatory and proactive protection by the law enforcement representatives that are deploying this technology and the governments that regulate them. And we're just going to switch to a new area, and I'll ask Cynthia to take over from here.
All right, thanks so much, Kate. Thanks to everyone who's here today. For my part, I'll be discussing how algorithmic policing technologies raise really troubling issues for the right to equality, the right to liberty, and the right to equality, especially in a way that may make them and their use incompatible with these rights of the Charter. So to begin with, Section 9 of the Charter protects our right to liberty and the right to be free from arbitrary detention. So in theory, law enforcement shouldn't be able to randomly stop us in the streets for no reason, and with no reasonable grounds to suspect that we're committing or have committed a crime. Algorithmic policing technology can reduce our enjoyment of this particular right in a few ways, which I think are best illustrated through the particular form of location-based algorithmic policing. The example we have of this type of technology in Canada is the Geodash algorithmic policing system currently used by the Vancouver Police Department. It's the sole predictive policing program we know of that is actually live and operational in Canada. It's been in place for a few years now, and it comprises a machine learning algorithm that predicts the top 6 neighborhoods where a break and enter is most likely to happen in Vancouver within any given 2-hour period. Now, some consider location-based algorithms as having less dangerous implications for human rights than person-based policing because you're not taking data about people, you're just taking it about location, time, date, and the crime type, in this case, break and enters in Vancouver. The Geodash algorithm, for instance, only uses those 4 types of data, and they also strip out any police-initiated reports because they don't want to risk there being either the fact or the perception of police bias. But in the case of Section 9 and our right to liberty, that generality and being divorced from individual traits is actually precisely the problem. Under Section 9 jurisprudence, individuals are detained arbitrarily and unconstitutionally if they're detained without grounds for reasonable suspicion. Now, reasonable suspicion must be specific by law to an individual's personal characteristics and behaviors. Location-based policing is the opposite. It's based on statistical trends and generalized inferences about neighborhoods that are completely unrelated to any specific individual who happens to be walking through that neighborhood. And so even assuming that forecasts, their algorithms, and their data are reliable, accurate, and unbiased, which are all highly questionable assumptions, the algorithmic forecast may be applied in a way that violates the constitutional right to liberty. For example, say someone is running down the street with a backpack. Maybe they're late for school, maybe they're late to meet a friend. An officer sent to that neighborhood who is informed that a crime is supposed to happen there at the time they happen to be there may now treat that person running down the street with more suspicion than if the algorithmic forecast didn't exist. The key thing here is that in both scenarios, nothing about the person or their behavior changed. They look the same, they still have the backpack, they're still running. But in one situation, without the algorithm, they're not suspicious, and the algorithm turns that situation suddenly into circumstances where they suddenly are. So that seems to violate the fundamental principle that reasonable suspicion is based on an individual. Now, assume that you do get over the generalized suspicion hurdle because maybe they do have specific characteristics that match a suspect, or they're acting in a way that the officer does think makes them suspicious absent of an algorithmic forecast. The presence of the algorithm can actually still distort the officer's formulation of reasonable suspicion. This is because reasonable suspicion is based on the totality of the circumstances. It's not just based on 1 or 2 things. It's based on, say, 5 or 6 different things, that any one of which may not be enough, but altogether rise to groundless suspicion. And so that involves a really high degree of discretion and flexibility on the part of the police officer, because it's really challenging to tease out exactly what someone did or didn't rely on, especially if some of those factors are unconscious or based on unconscious bias. So with that in mind, automation bias is one of these forms of unconscious bias. It's a widely documented phenomenon across multiple industries, which refers to the tendency of humans to rely on the judgments of automated decisions as superior to their own, even if they have reason to believe the technology is flawed. So it's very possible that an officer on the front lines may subconsciously rely on an algorithm to boost their suspicion of someone, even if they're trained not to, and even if they're intellectually aware that they shouldn't. The algorithmic forecast forms a kind of booster shot, tipping the totality of the circumstances over from a situation that wasn't suspicious to one that suddenly is. Again, divorced from the person themselves. The likely result of this over time is that we expect to see more unconstitutional stops happening across Canada, including detentions and arrests, both that are later found in court to be unconstitutional, but the damage has already been done, but also courts themselves may find stops to be constitutional where they wouldn't have before, since judges are also humans and are also susceptible to automation bias. The third and final issue when it comes to the right to liberty and algorithmic policing is that suspicion is not reasonable and not constitutional if it's based on discriminatory inferences or immutable characteristics such as race. We know overt racial profiling is unconstitutional, but a more subtle form of racial profiling can be embedded into the algorithmic forecasts themselves. This is a dynamic known as math washing, because the algorithms are trained on biased police data, which reflects the systemic discrimination perpetuated by the Canadian criminal justice system, but now that's hidden behind a shield of algorithmic so-called neutrality. So algorithmic policing can worsen the pre-existing racial discrimination and other forms of inequality in the criminal justice system, but without it looking like that's what's actually happening. And for us, this seems to be the real sticking point at the crux of the issue is we don't have data that exists that doesn't reflect inequality because that's just not our history. So how can we build tech on top of that data that somehow also doesn't perpetuate those issues? So if the problem is generalized suspicion, what if you could program algorithmic policing models to, in fact, be tailored to a person, their individual history, behavioral patterns, their friends and family, police records, social media activity? And so that's what we have going on here in Saskatchewan at the Saskatchewan Police Predictive Analytics Lab. Currently, they are doing something unique where they are only trying to predict future victims or people at risk of harm, such as runaway youth. But eventually, they want to move on to trying to predict violent or repeat offenders. And that brings us to the right to equality and freedom from discrimination. This right is protected under Section 15 of the Canadian Charter, and there are two things to keep in mind when applying an equality analysis to any situation. First, the analysis has to be intersectional. Specific different marginalized identities cannot be siloed out in particular analysis. So for example, you can't say someone suffered a form of oppression because they were Black and suffered this other form of oppression because they were a woman, for example. Black women experience unique forms of oppression and marginalization that someone who is only one of those things may not. And so that's important to keep in mind. And it's a concept created by Black feminist scholar Kimberly Crenshaw. The second thing is that equality has to be substantive, not formal. This means that it's not about treating everyone neutrally and mathematically equally as if we all started on a level playing field, because that's patently not true. It's doing what's needed so that we all end up substantively equal. With that said, algorithmic policing technologies threaten to violate the right to equality under Section 15 in at least 3 ways. First, algorithmic bias based on discriminatory data can unjustly increase already heightened scrutiny, police suspicion, and aggression towards members of marginalized communities, which again exacerbates pre-existing systemic discrimination. This both reduces the protection and the benefit of the law to which we all are supposed to be entitled under the Charter, and can result in self-fulfilling prophecies, where you end up in a police database due to police data, and then because you're in that database, you're now that much more likely to be brought up again in future police searches. Algorithmic policing results in what Virginia Eubanks calls feedback loops of injustice. Targeting members of a community ensures that they are in police databases in order to be put forward as targets in the future. And attempts to use non-sensitive data don't necessarily work because of the proxy data problem, where seemingly innocuous data such as shopping history or zip code or online search activities we now know are statistically tied to protected characteristics such as race and gender. Second, discrimination can occur based on socioeconomic status, such as income level, homelessness, and how much you rely on government services and social welfare. As Eubanks lays out in her book, Automating Inequality, people are often required to give up massive amounts of personal data in exchange for these services, and they don't have a choice because they need to fulfill their survival needs. So those who are already socioeconomically disadvantaged are particularly visible to law enforcement in 2 ways, in a way that implicates that particular characteristic. First, even in the absence of technology, they're physically more visible because they're out on the streets, for example, if they don't have homes. They're not allowed to exist in indoor spaces on private property, and so they just happen to be more visible to police officers who are walking down the street, and therefore more available to have someone be suspicious of them. But second, on top of that, there's a form of data hypervisibility that happens because due to the need to exchange their data for these services, their data is now that much more ubiquitous across different government databases, which themselves also have links to law enforcement. As Sarah Brain says, the retroactive nature of policing in an era of dragnet data collection means information is routinely accumulated and files are lying in wait. In that sense, individuals who are socioeconomically disadvantaged lead incriminating lives. Third, algorithmic policing technologies may not only further encode inequality and discrimination into the very fabric of the criminal justice system, even more so than they already are, but they simultaneously mask that injustice by virtue of their very reliance on algorithms to take on a veneer of scientific and mathematical objectivity or infallibility. This can lead to a form of techno-solutionist thinking, or the idea that all problems, even complex socio-political ones, can be reductively solved through technology alone. As a result, the technology both does not solve the underlying problems that go to community safety, such as affordable housing and healthcare and education. And we see that in current broader conversations around police defunding and abolition, for example. But even beyond that, it simultaneously sucks up funding and attention and resources that could go directly towards those problems, such as solving poverty, addressing income inequality, funding healthcare, and eliminating systemic racism. And those are not technology problems, they're problems of political will, which an algorithm is not going to solve. Thanks, and I will pass it over to Yolanda.
Hi, everybody. So I, in my portion of the presentation, am going to go over the recommendations in our report. Following the analysis that Cynthia and Kate have analyzed or have summarized, we've produced about 20 recommendations in the report, which are quite detailed. And of those, we've identified 7 which are priority recommendations. And they're priority recommendations because they require immediate action from policymakers and from law enforcement agencies in order to try to ensure proactive compliance with the Charter and with international human rights law in their adoption of these algorithmic policing technologies, you know, in a time when the courts have not had an opportunity to lay down the law with respect to these technologies. Our priority recommendations, which are on the screen now, but which I'll flip away from in a moment, are informed by 3 key ideas. So the first is that, you know, in our research, our findings are that certain uses of algorithmic policing technology are and will not be acceptable under international human rights and constitutional standards. So, for example, the unchecked use of algorithmic surveillance in public spaces, which Kate talked a little about, for example, the use of these surveillance algorithms to monitor protest activity, the unchecked use of this kind of technology without prior judicial authorization is not going to be compliant with international human rights law and unlikely to be compliant with the Constitution as well. And as Cynthia has just talked about, you know, relying on algorithmic predictions to justify detention or arrest similarly are lines that should be drawn at this time by law enforcement agencies and by policymakers. Second, we have, you know, there's a need to establish a constitutional and international law respecting framework at the outset of the adoption of algorithmic policing technologies and before their use becomes widespread and ingrained. And the reason why we make this recommendation is, first of all, you know, it's helpful to prevent as many rights violations as possible before they occur. Second, it is less costly and less resource intensive than having to, you know, try to turn the ship around once this technology is widely used and used in ways that may be problematic for our constitutional obligations. So, you know, in order to give effect to this need for a framework at the outset, our recommendation is that there be a moratorium placed on all algorithmic policing technologies until they can be properly studied. So there needs to be an assessment with respect to necessity and proportionality. So the necessity and proportionality of these techniques which are thresholds set by international human rights law. There also remain questions which are raised in our report but not fully answered, which require actually looking at the kind of data that police are using or propose to use in these algorithmic technologies. And for example, what are the acceptable uses of historic police data, which, as Kate and Cynthia have talked about, are pose serious problems for privacy, given the new implications that are raised by by facial recognition technologies, for example, and given our knowledge of what kind of biases exist in the data from our decades and centuries of systemic discrimination in our policing system. Our recommendation is that the federal government convene a judicial inquiry to review these issues and to produce guidelines with respect to the use of algorithmic policing technologies in a constitutionally respective way. The goal of all of this is to really promote proactive compliance by law enforcement agencies and by governments. It's not really it's not a good, so litigation after the fact is not really a good method of ensuring that there are no rights abuses. It takes a long time. It's very, it's very resource intensive. It can be very expensive depending on who you are, and it happens years after the fact. And when we're talking about policing and when we're talking about technologies and the kind of scope of activities that these algorithmic technologies can carry out, it means that there's a high chance, if we rely on litigation to kind of define where the limits of the constitutional rights are and where the limits of police's constitutional activities are, that it will be too late and too little, and that many people are going to be caught up and have their rights infringed upon if litigation is kind of the standard for when the police need to take activity. So proactive compliance is really what we're pushing for, and it's certainly what our recommendations are geared towards. And third, there is a need for immediate and full transparency from law enforcement agencies about what kinds of technology they're using, what they have used in the past, and how they're being used. Often we are finding out that algorithmic technologies are being used by police after they're already implemented. So for example, the Toronto Police Service adopted a facial recognition program which was entirely out of the view of the public for almost a year before it showed up in any kind of public document. It was actually a document that was put before the police board. We, in our research, sent out many freedom of information requests and were met with many assertions of privilege in statutory exemptions. So under the Freedom of Information Act, there's a standard exemption that police often rely upon, and I say probably too broadly rely upon, that they say exempts them from disclosing their use of these kinds of technologies because they constitute investigative techniques. There's also, as a practical barrier, we've both been met with requests for pretty exorbitant search fees in response to our Freedom of Information request, which pose like a very practical, serious barrier to access to this kind of information. And all of these things, kind of inform the need for transparency. And transparency is obviously important for a number of reasons. First, researchers like ourselves and civil society and experts can't monitor for potential abuses without understanding what technology is used and how. Second, for those individuals who are affected, there are really serious implications for their constitutional rights and their international human rights, for their rights to due process and to the right to a remedy. So the right to due process, is really affected where a person who's been charged, may not know or may not fully understand what technologies or what techniques were led to their charge. And in absence of that knowledge, there's really their ability to make a full answer in defense to the criminal charge is seriously compromised. With respect to the right to a remedy, the international human rights law provides for a right to a remedy where any of your international human rights have been, any of your rights guaranteed under international human law have been compromised. And this is particularly salient for example, criminal charges aren't laid or where they're withdrawn. And individuals may still experience privacy violations through surveillance technologies. They may still experience a wrongful detention, which subsequently, if the charges are withdrawn, they can't exactly remedy. And without knowing what kinds of technologies you're being subject to, what kinds of algorithmic policing techniques you're being subject to, the right to a remedy really becomes quite an empty right. Now, transparency is a long, sort of ongoing process, the way that we envision it with respect to these technologies. But as a priority recommendation, we're asking law enforcement agencies to share immediately what technologies they are using or have used or are developing or are procuring. And we're asking them to share this with the public and also with the relevant privacy commissioners. And similarly to the way that law enforcement agencies have to come out and speak about the uses of Clearview AI, facial recognition technology, just earlier this year. And we're also asking provincial governments to take a step to enact directives mandating law enforcement authorities to take robust transparency measures now and in the future, including publishing annual reports, undergoing thorough, comprehensive impact assessments prior to the adoption or the deployment of any of these algorithmic policing technologies. And finally, one of our most important priority recommendations includes a recommendation that policymakers and law enforcement agencies need to engage external expertise as they move forward. They need to be talking to experts from a variety of disciplines, including from legal disciplines, from technology disciplines, from policing and criminology and sociology disciplines. And they also, crucially, need to engage expertise from affected and traditionally over-policed communities who are often in a better place to sort of identify where issues may arise and where their rights are going to be affected going on a preemptive basis. And as I say this, I do want to take the time. It's a little weird now that we're doing all of this virtually, but I do want to emphasize this by making a land acknowledgement at this time. We are, all of us, on, assuming we're in Canada, are on land that was traditionally home to Indigenous peoples, and Indigenous peoples are very disproportionately affected by the criminal justice system that we are living in right now, and also will be disproportionately affected by steps taken in algorithmic policing without the appropriate kind of limits and the appropriate frameworks at the outset, which is really what our recommendations are targeted towards. So with that said, I think that we're going to turn it over to a Q&A now. And I understand that you can put your questions in the chat and we can get to them that way.
So from the first question is, do you think that there should immediately be certain no-go zones, i.e. places where AI simply cannot be used at all, even without getting further information than we already have?
I can answer this a little bit. There are areas that we know are not acceptable. As Cynthia's touched on, the use of algorithmic predictions to justify somebody's detention is certainly not acceptable, given that that's very generalized information that's being used to inform reasonable and probable suspicion, which isn't something that our Constitution allows for. Also, the surveillance of a kind of like mass surveillance and monitoring through algorithms of communications that are taking place in a public space is not acceptable. There are privacy implications still in communications that you're putting out into the public and in yourself being in the public. The international human rights laws has recognized that. The Constitution also recognizes that through their definition of what privacy is. And police services often kind of conduct themselves as though there's this dichotomy between private and public, which means that anything that happens in the public is fair game for surveillance. We know that this isn't true under the laws, and without prior judicial authorization, police services can't constitutionally or in compliance with their international human rights obligations monitor sort of these public, quote unquote, public conversations that are happening.
I think that there was another no-go zone that we identified in our report, which has been touched on, but it really does seem like an impenetrable impasse under Section 15 to rely on inferences drawn by fundamentally broken and biased data sets that our criminal justice system has produced. It's really fundamentally turned policing on its head to take a system that was essentially individually processed case by case by case by case. And in each and every case, we will look to, hopefully, best case scenario, we might be able to identify bias through some means. And sometimes we see that in racial profiling litigation, but our system was never designed to create systemically useful data sets. And it really is quite the opposite. And so Section 15 has been historically underserved and underprotected in Canada's criminal justice system, partly because a complex legal history about the idea of police independence and how we've historically not subjected police services to statutory powers. There's a lot that has come down to discretion and policy and deference to a police service. That's not a constitutional necessity, not at all. Certainly our national security agencies are subjected to big data regulations, and the way police services are not. But it's been very difficult for Section 15 litigation because we're having to prove bias in state action as opposed to legislation, which is that much more complicated. And so in any event, we see this as a fundamental issue that we shouldn't be trying to mitigate. It should be viewed as a total roadblock.
Great. Next question. I'm happy to take this one. I'm curious about your thoughts on how personal use tech intersects with these issues, such as Amazon Ring police partnerships in the US. I'm so happy someone asked this because this is a huge issue, and it's one that we did not get to dive into in our report as much as we wanted. Because it's a report about policing and criminal justice, we really focus on the duties and obligations of the public sector bodies and law enforcement agencies. But there's a whole other, actually, I'm hoping to pursue this specific intersection in future research of that intersection between private technology vendors, consumer technology vendors, and police, just like in Amazon Ring, because they're just one example of private surveillance networks where it's private companies collecting all of this data, but then they end up back channeling it to police. And if that particular intersection is not identified and regulated, then we really end up with an informal ossified back channel and a workaround around Section 8 privacy protections in Canada or the Fourth Amendment in the United States. So we are very concerned about this. We're hoping to pursue it more directly and in future work, just to figure out how should those particular relationships be regulated, both in the context of online platforms who give data to police officers on one-offs. So example, Google, Facebook, Twitter, they aren't built for surveillance and law enforcement purposes, but they do give information to law enforcement. And then in more purpose-built technology and platforms like Amazon Ring, like neighborhood apps, like there's an automated license plate privatized database in the US, but that anyone can access, including law enforcement and private investigators, where their whole point and their whole business model is specifically to ongoingly channel data to police officers, not just as one-off requests. So that's something that we definitely encourage people to look more at. And if someone's looking for something to pursue research-wise, I think that's a really good avenue to go down and a needed one.
We see another question here from Sarah about how can, as defense lawyers, we protect human rights and challenge bias. If it is not in the disclosure, should there be an obligation to disclose the use of it? In simplest form, the answer is yes. And wow, what a complicated issue. We've talked about so many steps that we recommended for governments and law enforcement to do proactively and on a mandatory basis, because not only does that protect some of the keystone rights that are the focus of our report, but it also has spillover effects into how meaningful access to justice and accountability mechanisms can be. The disclosure of use is certainly a minimum but not sufficient step that would need to take that they would need to take if we're going to go down this road further. But it has to be looked at holistically, because there's a lot of research that's talked about transparency is not enough. And when you talk about concepts like procedural fairness, you have to look at the system that the particular project is being inserted into, and how capable is it of responding to the human rights issues at stake. Virginia Eubanks has talked about how algorithms are often introduced into low rights environments where there's a low expectation of accountability, and a low ability to respond with a necessary challenge. So you need to front load the program with procedural protections like disclosure, but certainly that's not necessarily going to get you over the necessary hurdles.
And I'll just add to that in terms of a reference. If you go to page 135 of our report, 135 to 136, we actually provide a specific list of items that defense counsel might want to consider asking for in disclosure, so if they suspect that algorithmic policing tech has been used in your client's case. Next question is, did we also consider the use of risk assessment algorithms in bail hearings? Great question.
I'm happy to jump in on that one more quickly. I mean, we know that a feasibility study was done a number of years ago. I as a practitioner in the justice system, have looked at this issue closely. It wasn't discussed at length in our report. I've looked at it elsewhere. I'd be very surprised if a feasibility study found that algorithmic risk assessments could be introduced in bail hearings in Canada. They've been rolled out in the United States, certainly, but I view that as a political development, not a necessity, not a development that's happened necessarily or because they're necessarily a better way to go about assessment of risk. And actually, many more reasons why they would be found to be excluded in Canadian courts than useful. But often in the United States, we've seen them because they've been much later than Canada has in moving away from a cash bail model. You see it on TV where individuals can't make bail because they can't put in tens of thousands of dollars into the court. It's a financially inequitable system of bail that's still existing in the United States. And so often when you're seeing these tools introduced, it's almost like a replacement for that. When really we don't need an algorithm to give us permission to view someone as low risk. And Canadian judges are already expected to do this as a matter of common sense and legal principle, and we don't need algorithms to be able to accomplish that objective.
Great. Next question. Maybe Yolanda might want to take this one. It is, sorry, a lot of great questions. Thank you, everyone. I lost. Okay. In what areas of law enforcement, if any, do you believe AI can have a positive impact?
So, I mean, this is kind of a hard one. Our research is very much engaged at looking at kind of issue spotting potential violations. So I didn't, we didn't spend 2 years looking for ways that AI could benefit the practice of law enforcement. What I will say is that, kind of from a very holistic kind of philosophical viewpoint, one of the main problems with the use of these kind of AI technologies by powerful actors, by states, by police, against those who they're governing, is that it is this power imbalance. Is that it's always, these technologies generally developed by private companies who are looking to make a profit. The only people who can give them that profit is if they, design it for use by the government or by police services. And there's not really like an equal kind of access to this kind of technology and the capabilities from communities, and in particular from communities who are being disproportionately affected by policing. So, I mean, in terms of where it can have a positive impact, I think that there's an element, there's a potential for positivity if you can turn the technologies around and use them to kind of study and understand maybe police activities, which is really what the AI, when it's trained on police activities, is predicting, right? Like any kind of predictive algorithm that is looking at, at decades and centuries of police activity is going to be expert at predicting police activity. It's not going to be expert at predicting what police activity is supposed to be a proxy for, which is criminal activity. So, I mean, we see it in certain activists in Latin America, I believe, where they've used, they've used this kind of technology to try to predict where, shootings are occurring and things like that. And, just turning it around and designing it with the benefit of the community in mind, I think is one of the ways that these technologies can be helpful for in, I mean, not exactly a law enforcement context, but adjacent to it.
I think it's also worth noting that a question like this is really easy to risk narrowing the debate as to what the problem and therefore the solutions actually is. Because if we go directly to, can AI have a positive impact on law enforcement, what is that impact we're looking for? Because if we think that law enforcement is in itself a problematic institution, for example, then are we just using AI, if it does work, to more efficiently perpetuate a systemically racist, anti-Black, anti-Indigenous system, for example, in which case it may have a positive impact on police and on law enforcement, but it's not actually the impact that we want for society. For that point, I think I would refer people to a particular report by the Stop LAPD Spying Coalition called Before the Bullet Hits the Body. And they have one of the clearest articulations of this particular line of thought, where it's not about making algorithmic policing better for its own sake. You have to look at what the ultimate purpose is. They say that I'm quoting here, critical race theorists contend that the complete dismantling of racism in one context necessitates considering other forms of oppression in other contexts. So a more equitable application of the LASER program, which is the LAPD's former predictive policing program, should not be the goal, because it's a colorblind policy, again, the idea of MAC washing, and it doesn't address the core problem, which in this case is institutionalized racism, classism, and poverty, which these types of AI-powered policing are a manifestation of. Okay, so the next question is, what would you say to those who argue that predictive policing only reflects the biases in society and that they're not creating anything new per se?
I also think, I think Cynthia's previous answer touched on that perfectly, which is like, what are we really talking about here? Is it acceptable for us to continue perpetuating existing biases in society? I don't know, it hardly seems like we've also been faced with this question before, and it hardly seems like really a justification for it. I'd also like to note, as Kate touched on in her introduction, the difference with algorithmic policing technologies versus just the practice as usual is that the selling point of these technologies to police services is that this can do so much more than what your officers can do. It can do more, it can do it faster, and to ingrain our existing legacies of systemic discrimination through a technology that can do so much and do so much so quickly. Seems like it is an additional problem. It's no longer just even the continuation of the status quo. It is advancing the sort of entrenchment of discrimination in our system. It also, the courts have over and over and over again now recognized that there is systemic discrimination in our criminal justice system, and it hardly seems to me like an acceptable justification under Section 15 to say, well, we're just continuing things that the court has already said are a huge problem in Canadian society, and we're just doing them faster and more efficiently.
I think I would just add to that too, that as part of our research, we did have the opportunity and the privilege to speak to several representatives of Indigenous communities, Black communities, racial justice activists, and the predominant view we got from them is that this technology is nothing new. They draw a straight line from whatever the RCMP did when they were first enacted to police Indigenous people, down to carding through the little 209 cards in Toronto, to deploying algorithms. And I think I'm paraphrasing from what they told us, but they basically see it as an extension of tools used to justify state violence against Black and Indigenous people, whereas in the past, you would have used pen and paper to justify why you chased down a Black teenager in the streets, and today you would use an algorithm for that exact same purpose. Is something that we heard a lot of.
Yeah, and just to, I mean, in terms of our language around it, I think it's right, there's nothing new, but there is a new danger in that you have this scientific veneer of something bright and shiny and new, and maybe we think that technology is going to save us from our problems and that type of thinking. I think there's a danger that it's nothing new, but it maybe is worse because we're distracting from other more positive, optimistic, evidence-based reform in our justice system, and we're replacing it with something that might actually perpetuate and hide bias in our justice system.
Another question is, what kind of additional research or mobilization do you think could help marginalized communities counter algorithmic policing? For example, what kind of research should an Indigenous or Muslim community organization undertake to build on this report? At this point, I might say, maybe we're not the best people to answer this question. I'm very cognizant right now that there is not a Muslim or Indigenous individual on this panel. So I would suggest actually going to them. And particularly, again, even though we're focusing on algorithmic policing technologies because they raise so many problems in themselves, we have to be careful that they don't become a red herring where we're focusing so much on the technology and making them better and countering them that we redirect resources from, you know, maybe Indigenous and Muslim communities are working on other issues that they find more pressing, for example, but we can't know that until speaking with them to find out what should be done.
Thank you so much, Cynthia. Sadly, I think that we need to stop for today's talk. Thank you so much for that insightful conversation and for your answers to those great questions. And very sad to have to stop the conversation. I feel like we could have continued the whole afternoon discussing also. And there is one of the comment should the demonstration that there is a violation of human rights be on the victim or on the police, maybe of the law enforcement agency, to have to prove that what they're doing is in compliance with human rights? Maybe we need to rebalance this. And as you said, Cynthia, I cannot emphasize enough the need to have more conversation and more thought leadership coming from Black and people of color in Canada about those issues, to be able to hear from those who are the first victim, the main victim of those kind of technologies. And for me to have a plug about so yesterday we announced Can Compute, a new call for proposal, especially designed to amplify those voices about those issues. So with the Digital Justice Lab, you can find all the details on cancompute.ca. And about the report, we added again the link in the chat for those who would be interested to download the report, and it's also available on the event page of today's talk, and obviously on the Citizen Lab website. On that note, I would like to thank you again, Kate Robertson, Cynthia Ko, and Yolanda Song, for being with us today and to share your thoughts about that technology. And thank you for everybody in attendance with us today. Thank you. Have a lovely remaining of the day, and see you next week. We have a event, and in 2 weeks we're gonna start again as we did over the summer, those regular conversation about tech and society in Canada and across the globe. Thank you, everybody. Have a nice day. Bye-bye.
Thank you.
Well,
Thank you.